session. The Honorable Harvey J. Judge presiding. All persons having business before this court draw near, take attention, and will be heard. In God's sake, the United States of America, the state of Florida, this honorable court. Please be seated.
Good morning. Welcome to all. We just have one case on the calendar, which is a little different than where we started all of this. As you saw, I'm the presiding judge today. My name is Harvey J. And in the midst of many firsts, first here at the reconfigured 5th DCA, this is my first time presiding at the 5th. I also have the privilege of serving here with Judge South. As many of you know, he was a very esteemed, well thought of, well-credentialed trial court judge for many years, and I'm certain is going to be an outstanding appellate judge. The same can be said for Judge Boatwright. This is my first opportunity being with both of them in an oral argument. As I understand it from Judge Boatwright, this is his first live oral argument as a 5th DCA judge. So again, another first. But Judge Boatwright, like Judge Soud, was very well thought of on the trial bench, highly regarded, and obviously well-credentialed, and I know will do a great job as an appellate judge. But as I said in the beginning, we just have one case on the docket. That case is Olson versus First Team Ford. Mr. Gowdy, are you prepared to go forward?
Yes, sir.
And for the court's benefit, the court is the timekeeper, among other duties here today. How much time would you like for rebuttal?
5 minutes, Your Honor.
All right. When you're ready, please proceed.
May it please the court, Brian Gowdy on behalf of Mr. Olson, the plaintiff and the appellant. We're here today on the Graves Amendment. The plain text of that amendment says in pertinent part that an owner of a motor vehicle that rents or leases the vehicle to a person.
Scotty, if you give me 1 minute, I can't seem to get the clock started.
That's fine. I like having a few extra time.
And that's it. Thank you. That's why we have the marshal with us today. So I thought it was going to be seamless. It was not, but if you would please proceed, Mr. Gowdy.
All right, take two. We're here on the Graves Amendment. The plain text says the owner of a motor vehicle that rents or leases the vehicle to a person is immune from liability. The issue before the court is simply this. Construing the facts in the light most favorable to Mr. Olson, did First Team Ford carry its burden of proving, as a matter of law, its affirmative defense that it rented or leased the expedition vehicle to Mr. Matthews? The issue is not whether First Team Ford and Matthews agreed to service the Tahoe. The issue is not whether Matthews intended to get an oil change. Turning to this court's binding precedent in Romero, it held that an owner who merely loans a vehicle to another in the absence of consideration exchanged for the use of the vehicle does not rent or lease the vehicle.
Mr. Gowdy,
yes, sir.
You've cited to Romero and Thayer in your brief, correct?
Yes, sir.
So do you think those cases are in conflict?
No, sir.
Okay, and why not?
Because Romero deals where construing the facts in the light most favorable to the plaintiff, that it was a complimentary loan vehicle to a customer, not for a service. Thayer deals with a case where the undisputed facts were that it was for service and that there was consideration paid, and that's critical. Says it in the case, there was consideration paid for that service, which was construed also as consideration for using or renting the vehicle. We don't have, here the facts are highly disputed.
Mr. Matthews did bring his vehicle in for servicing. That was his testimony, correct?
That was his testimony, but that testimony will be discredited at trial. He had a motive to lie, Your Honor. He is the general manager of the defendant, and thus he has a motive to lie to protect his business from liability.
Were you able to raise a factual dispute in the record, though?
Yes, Your Honor.
Okay, and where was that?
There were 5 exhibits attached to our response, Your Honor, including Mr. Matthews' deposition. And the law is well established that just because a biased witness comes in and says something, it doesn't mean you have to accept it. And he gave 2 reasons that he purported to have taken this vehicle. One, and this is in his testimony, he says he and his wife were thinking of buying the Expedition to replace the Tahoe, and he wanted to drive it home. Yes, Judge Jay.
Well, and I would like to hear about your position on these genuine disputes of material fact, Mr. Gowdy, and you've referenced the first one. This is Mr. Matthews' deposition where he definitively said that his intent in signing the agreement was to take the vehicle home, have his wife look at the vehicle so she could make a decision about whether to buy it or not, correct?
Correct.
And then later some questions are asked related to that, but it seems to me those questions were based on whether in fact the oil had been changed, and we know the oil was not changed here.
Which would tend to have a reasonable juror think this oil change is all contrived.
Well, is that not speculation too? No. I mean, those later questions, Mr. Gowdy, about if your oil had been changed, you wouldn't have taken the car home. And I know we have to rely on summary judgment evidence. Would that not be speculation?
Well, no, I don't agree, Your Honor. Again, Mr. Matthews gave 2 very different reasons.
Well, and make sure you understand my question, Mr. Gowdy. I see a definitive question and answer in his deposition. It's the record 774, lines 3 through 9, where he says it was his intent. The reason behind signing the agreement was to take the car home. But then my point, and maybe you disagree with the court's point, trying to perhaps enhance your genuine issue of material fact, but it looks like after that, he's asked whether if the oil was changed, if it would have changed the dynamic, and that's when it seems to this judge that that's speculation. Am I wrong about that?
I guess I'm not understanding what you think is speculation, whether the oil was changed or not.
Well, we know it wasn't changed, and the question is, would you have taken the loaner vehicle home regardless?
Oh, I agree that's Mr. Matthews speculating. Yes, yes, yeah. I agree with that. I'm sorry, I didn't understand your question. Now I do. Mr. Matthews was speculating in his testimony, and I don't think that's really germane. I want to get back.
Well, to follow up on Judge Jay's question, was that ever rebutted?
It was what rebutted?
The question that he just asked you in regards to Mr. Matthews saying that if he had not taken the car in to get service, then he would not have taken the loaner home. So I believe that's what the trial court kind of focused on. Did you able to raise that as a factual dispute in the record?
Yes, because well, first of all, if I could just as a preliminary matter, I think you're making the wrong analysis, Judge Boatwright, and I'll explain that more in a moment, but I'm going to answer your question first. Because what his intent was, and this whole oil change doesn't answer the question under the statute about renting or leasing, and I'd like to give you a hypothetical in a minute. But to answer your question, there was evidence calling into question Mr. Matthews' entire credibility about the oil change. That evidence was, first of all, every customer who takes a vehicle home for a test drive must sign the loan vehicle agreement that he signed. Not for a service change, but for a test drive. Number 2, the agreement that he signed is not a rental or lease agreement. Number 3, Mr. Matthews never paid any money to take the Expedition home for a purported oil change. Number 4, there were no service records created at all at the dealership documenting that this was brought in for an oil change, even though the service manager testified that normally in the course of business, such a record would have been created. And number 5, no such records were ever produced. So this all tends to prove, Your Honor, that the oil change is contrived, and given that we have a biased witness who is the general manager of the defendant, the jury could discredit it. But if I could get off the oil change and talk why that's really a red herring at bottom, the question is, was there consideration for a rental or lease. That's what the statute asks us to do. Let me give you a hypothetical based closely, but a little bit different on the Thayer case. Suppose that I call my friend.
Mr. Gowdy, and we certainly want to hear your hypothetical.
Okay,
I don't want you
but I want to answer your question. So.
Well, and I'm back to what you just said. You said it's a red herring about the intent of why he signed the agreement, but again, I'm just going by what the judge did. It seems like serially the judge talks about it's undisputed his intent was emanated from bringing in the car for service. And in fact, in the transcript, she even says that's the reason he signed the agreement. So that seems like it wouldn't be a red herring. That would seem germane to why the court granted summary judgment.
Well, it's not a red, it does show why the judge below erred. I agree with that. So I didn't mean to say it's a red herring, but I meant in terms of the legal analysis, the trial judge erred in getting caught up on intent. When we're talking about rental or lease, it falls under the general purview of contract law, which for a very long time has not looked at parties' subjective intentions. This is, Williston, Corbin, 101 contract. We looked at the objective indicia about whether there was an agreement and an objective consideration about whether there was a meeting of the minds and consideration. And we would say there's a disputed issue of fact about whether this oil change service agreement ever happened between First Team Ford and Matthews or was simply contrived after the fact to escape liability for First Team Ford. So the subjective intent of a party to a contract has never been relevant in the law, at least for a very long time, for over 100 years.
So it may not be relevant to intent, but would it be relevant to the question of whether or not consideration exists?
It would be relevant for a jury to weigh at trial, yes. But it's not the fact that I have the intent to have my vehicle serviced. That means as a matter of law, I formed a rental agreement with the dealership. And if I could try to get to my hypothetical, if a friend calls up his friend Randy Marion, who owns a dealership, and says, "Hey Randy, I'd like to bring my vehicle and get the oil change. Could I do that?" And Randy says, "Sure, bring it over Saturday morning, we'll change it and I'll loan you a vehicle so you can drive it on Saturday." And it's completely done as a friendship. That's not a rental agreement, that's not a contract, that's a gratuitous bailment. And this court held in Romero that a gratuitous bailment is not covered by the Graves Amendment, squarely held that.
Isn't that the distinction, though, in the Thayer case versus Romero? Actually, in Romero, the agreement had the words bailment, where the agreement in this case does not have bailment.
That is a distinction, but it's a distinction without a difference, because this is a bailment. And the fact is that, at least construed in the light most favorable to Mr. Olson, that First Team Ford, through its general manager, Mr. Matthews, allowed Mr. Matthews as an individual to take the expedition home to show his wife and to see if it would fit in their garage and as a complimentary loan vehicle. And that lines up perfectly with Romero. Now, if they want to come to the jury, Your Honor, and say, "Oh, it was really an oil change," they can put that evidence on. They can put the evidence of the intent. And let's see if the jury agrees that there was a rental agreement that came through this oil change. I agree that there's differences in Thayer, but they're in our favor. The difference in Thayer we had customers who were an arm's length customers. They were not the general manager of the dealership.
Another question, Mr.
Yes.
Gowdy. An argument you make in your briefs, and you've made it again today, deals with credibility, Mr. Matthews' credibility. When is that a feature of the court's analysis on a motion for summary judgment? I mean, what would you say? When should the court consider the credibility of the witness?
whenever the opposing party has a reason to attack the credibility. It could be a conviction. It could be he has a motive to lie. It could be an inconsistency, like I brought my car in for an oil change, but yet I didn't get the oil changed. It could be many things that we have in this record. We don't have the conviction, but we do have a motive to lie. He's the general manager of the defendant. He's protecting the defendant from liability. We have an inconsistency in his story that he brought the vehicle in for an oil change, but there's no record ever created. If you bring your vehicle in for service, and their service manager testified to this, a record will be created. Even if the service isn't completed, there's no record that this happened. And we have the admission by him that the oil never got changed. How is it that the accident prevented the oil from getting changed? I mean, there's lots of reasons. So, and I think the answer to your question is anytime you have a reason to do so. I want to, on the Thayer, I don't know, I hope I answered your question, Judge Jay, but on the Thayer case, I'd like to read, Judge Boatwright, the dealership then received the opportunity to service the Pope's car and received payment from the Popes for performing that service. The Popes agreed to bring their own car to the dealership and pay for the repairs in exchange for the use of the vehicle. I'm quoting from the case. You don't have those facts here. You don't have anything to indicate other than Mr. Matthews' self-serving claim that he brought the vehicle in for an oil change of any type of agreement between him and First Team Ford. And so, unless the court has more questions, I'll reserve the balance of my time for rebuttal.
Thank you, Mr. Gowdy. So reserved, and it looks like I did that. Thank you. Ms. Klein, are you prepared? Yes. All right, please come forward.
Good morning, Hinda Klein here on behalf of First Team Ford. We respectfully suggest that Romero does not compel a reversal in this case because this case is distinguishable on a number of factors and because the 11th Circuit Court of Appeals has issued its decision in the Thayer case after Romero issued. And we believe—
Ms. Klein, let me start with you where I perhaps ended with Mr. Gowdy. Why is there not a genuine dispute of material fact here? And Mr. Gowdy referenced various things. One, the fact there's no service record, repair order in this record. Two, the testimony of Mr. Matthews, where he, as I read it, categorically said that he signed this agreement to take the vehicle home to have his wife look at it. Why are those things not enough to create genuine issues, genuine disputes of material fact?
Well, first, the fact that there was no service record is not in and of itself an affirmative fact that would give rise to the ultimate conclusion that this was just a subterfuge, as opposing counsel has argued. Mr. Matthews volunteered at his deposition that he saw this oil change as an opportunity to take the car home and to measure his garage. But that doesn't mean that there wasn't the secondary or the primary reason wasn't to get the oil change in the first instance.
Well, his testimony, and I believe I read it. If I didn't, I can read it for you. I know you're well familiar with it, but he said, I thought categorically that the purpose behind his signing of the agreement, your intention in signing this agreement was so that you could take the vehicle home overnight and show your wife so she could decide whether she wanted to buy the vehicle. Mr. Matthews, answer yes. That seems pretty definitive, and I see in the transcript where the court says just the opposite, that his intent was to have the vehicle service, and that's why he signed the agreement. So why Why is that not a genuine dispute of material fact?
Well, actually, on pages 441 and 442 of the record, and that's Mr. Matthews' deposition, he actually testified, as Your Honor had previously pointed out, that if the oil change had occurred, he would not have taken the vehicle home.
But isn't that speculation, Ms. Klein? And don't we have de novo review here? I mean, that strikes me, that we know the oil wasn't changed, correct?
Well, the accident happened 15 minutes after he left the dealership, so...
And I understand that, and thank you for your candor, but it's undisputed, correct, that the oil was never changed?
Correct.
So the questions about, well, suppose the oil was changed, are those not calling for speculation? And isn't that the kind of evidence we're not allowed to consider on a motion for summary judgment?
Well, first of all, there's nothing here to dispute that the initial intent of Mr. Matthews was to get his oil changed. While they disbelieve that, that doesn't give rise to a genuine issue of fact. He also honestly testified that he saw it, and this is on page 442, as an opportunity to, at the same time, drive the expedition home. I don't see that that's a problem, or that nullifies his initial intent to get the oil changed.
And again, to follow up on something Mr. Gowdy said, and this deals with credibility, and this is hypothetical. I fully realize it. Ms. Klein, let's assume, for purposes of this question, that you have an unwitnessed accident. Plaintiff says, I fell down at such and such a location. Undisputed, based on the plaintiff's testimony. Plaintiff moves for summary judgment and says, well, I fell at this place at this time. There's no evidence to the contrary. Is the plaintiff entitled to summary judgment?
Well, I think it would actually depend on whether or not there could be a circumstantial evidence, calling that into question. But there isn't any circumstantial evidence.
Don't we have that here, though, with the service order, the repair order that's not in this record? Isn't that the type of thing that goes to credibility that a jury is allowed to evaluate?
No, the jury is, on a summary judgment, the trial court is not in a position to evaluate credibility. In your
My
hypothetical.
So you would say, well, it's undisputed, plaintiff gets summary judgment, even, and let me fill in some facts. And I'm thinking about a case I was tangentially involved in 1992, Roach versus CSX, in FELA claim. And that was the plaintiff's argument, that nobody but the plaintiff was part of this, and therefore the plaintiff was entitled to a directed verdict. But the plaintiff didn't fill out some paperwork after the accident happened, as it turned out. And the trial court denied the motion for directed verdict. The jury did not find the claim to be valid, and Roach versus CSX is the claim. And my former court, the first DCA, said there was a fact question because of basically the credibility of the plaintiff in that case. And I know that's not our circumstance. We don't have a FELA claim. But the point, I think, is in circumstances where even you have an unwitnessed accident or no one other than Mr. Matthews could talk about his intent, isn't it permissible to present other evidence that undermines that definitive statement? That's my question.
Not unless it directly contradicts that statement. What Your Honor was just suggesting was a case in which the issue was whether the court should have granted a directed verdict. Here we are on summary judgment. On a directed verdict, you have people who have testified live, who are before a jury, and the jury is instructed to analyze their credibility. On a summary judgment, the trial judge is not in the same position. The trial judge must rely on the cold, hard record, and if we were to apply opposing counsel's arguments here, that any time that the trial judge or opposing counsel questions the credibility of a witness, that's sufficient in and of itself to warrant a denial of summary judgment, then what are we going to do with expert affidavits or other things where there are people who theoretically have a bias?
And it's a good point, Ms. Klein. Where do you draw that line? I mean, credibility, and that's the reason I ask him the question, because is that a feature of every summary judgment hearing? I don't believe it is, but in certain cases it seems, again, to this judge that maybe it could be. And perhaps this is that situation where you have other evidence that's not there. For example, the repair order, no service paperwork, the service manager saying you would have a repair order if the car was brought in for service. Doesn't that undermine this intent to have the car serviced?
Well, the interesting thing about that, and actually opposing counsel brought it up at the trial court level, was that this particular service manager had just been in that position for only a few months. He did not have personal knowledge of the circumstances surrounding the agreement with Mr. Matthews, and he couldn't really testify as to whether there were circumstances which would give rise to the absence of a service record. Because Mr. Matthews was, in fact, the general manager. Maybe there was, at the time this happened, a possibility that, where an employee takes a vehicle, there isn't a service record until the work is done. There were actually a lot of questions that were raised by opposing counsel in rehearing as to issues that could have been explored before this summary judgment that weren't. And I would suggest that that is one of them, but I don't think that the mere fact that there wasn't paperwork on the service is in and of itself enough to raise a genuine issue of material fact.
Let's set that aside. Does the intent matter here? Did it matter to the trial judge?
Yes, because we're looking at the agreement at the time that it's entered into.
What do you do, though, with his deposition testimony saying his intent in signing this agreement was to take the vehicle home? Isn't that a quintessential genuine issue of material fact? I just don't know how you get around that, Ms. Klein.
Well, I don't believe so, because who's to say that there can only be one intent? He was in for an oil change, and he said, great, maybe I'll take it in for an oil change so I can get a loaner car to take home.
Well, and thank you for that. That's a good response. But if intent matters, and there are two potential intents here, isn't that every reason to have a jury evaluate it?
I don't believe so. As a matter of fact, and I just noticed this a couple minutes before oral argument, I was reviewing the Thayer case again, and interestingly enough, the Popes dropped their car off for service the day before their wedding and took the loaner car on their honeymoon. And it may very well have been in that case that they intended to drive somebody else's car down to Florida on their honeymoon rather than put the miles on their car and not have to pay for it. So I don't see that there's any exception in the Graves Amendment for individuals who take their car in for service and at the same time enjoy having a loaner vehicle or want to use a loaner vehicle for a different purpose.
Is that, and I'm sorry, I didn't mean
Go
to.
ahead.
Is that not Mr. Gowdy's point? The question of fact is whether or not, if I heard his argument correctly, the dispute is whether or not the car was in fact taken in for service at all. Am I misperceiving his argument?
I don't think you are, no. I think that's exactly what he's arguing.
So because of Matthew's testimony, because of the absence of service records, your contention, if I'm hearing you correctly, is that that is not enough to defeat summary judgment when Matthew says the car was taken in for service.
I believe so. I don't think it's enough.
Is whether or not the service was actually completed on the day he took the vehicle into the dealership a red herring?
Yes, I believe it is, because obviously there are all kinds of reasons why and when service is or is not
So
completed.
why not take his car back home? Then why not did Mr. Matthews just take his car, the Tahoe, back home? Because he wanted to test drive the other one to see if
Right.
it fit in the garage.
But, you
So
know-
so my question is, does that change the nature of the arrangement from service to loaner vehicle?
No, no, there was no question here, and there, no evidence here that what he testified, namely that he brought his car in and it wasn't done by the time he was leaving because it was a busy time right before Christmas. I think it was December 21st. Because it wasn't done, he took the car home. I agree, he could have done all kinds of other things, but that doesn't change the fact that in this case, he took his car in for service, he had a legitimate explanation as to why he left it there rather than driving it home. And that explanation is, it may seem unreasonable to opposing counsel, it's not out of the realm of possibility, and he very clearly, voluntarily testified. And by the way, I wanted to take this particular car because I wanted to measure my garage.
I don't think reasonableness is the question. It's not, what he did is not unreasonable. And certainly, I think most people have had the experience, you take your car in for service, it's expected to be done on the day you take it in, and then they need to keep it another day or two, and customarily the dealership will tell you, keep the loaner overnight. Do you recall whether the record bears out when the loaner agreement was executed?
What time of day?
When in the nature, I don't know that I need precisely the hour and minute, but was that at the end of the day before he left for the evening, or was it when he dropped the car off? Do you have a recollection of that?
I do not have a recollection of that.
Thank you.
Ms. Klein, in order to have a valid rental agreement under the Graves Amendment, you need consideration, correct?
Correct.
What would the consideration be when the vehicle was not actually serviced?
Well, the consideration was he left his car in for servicing, intending that it be serviced, and presumably, and there, again, there's nothing in the record, he was going to pay for it. So, under Thayer, that in and of itself is sufficient consideration. And there's no question here that, you know, had he had the service done, he would have paid for it.
Would he have still taken the loaner vehicle home? Now, that may be speculation, frankly.
Well, he testified he would not have.
Okay.
He did testify to that under oath. In addition, the loaner agreement does have a number of things that he agreed to in consideration for the loaner. He accepted full responsibility. He agreed to indemnify and hold harmless the dealer. He agreed to bring it back in good condition. He also agreed to grant the dealer a lien and security interest on his car to be held in the event that he didn't bring the vehicle back or in the event it was damaged.
Below, Ms. Klein, the argument was on behalf of the dealership. The consideration in this case was that Mr. Matthews left the car for servicing, correct?
Correct.
That was the argument,
Yes,
correct?
yes.
What you're telling us now was not the argument below. As far as these other things that could have been consideration, the argument of the dealership was he left the car for servicing, therefore there's consideration.
Correct.
Thank you.
We would respectfully request that, under the circumstances of this case, that this court should follow the Thayer 11th Circuit case. It is the sole case in the United States addressing this specific issue. Happens to be a Florida case as well, and it very clearly states that it is sufficient consideration for a customer, and in this case, Mr. Matthews was a customer.
Question about Thayer. As you know, Ms. Klein, it's a Circuit Court of Appeals, 11th Circuit Court of Appeals, Federal Circuit Court interpreting a federal statute. Does that enhance it in any way? Meaning, does that enhance the reasoning in Thayer?
Yes, I believe it does, under the Home Devco versus Silver case that we cited in our brief, 26 Southern 3rd, 718, 4th District, 2010. that because Graves is a federal statute, the 11th Circuit Court of Appeals decision should control in this case. I know opposing counsel brought out some other authority in his reply brief challenging that argument. The Doe versus Pryor case that he had cited is an 11th Circuit case. In that case, involved the interpretation of a state statute, not a federal statute. And the Carnival versus Carlisle case that was also cited, 953 Southern 2nd 461, 2007, had to do with whether the third district, I think, in that case, was correct in following one of several federal court positions on the assumption that it should follow the majority rule of federal courts. And both of those cases said under those particular circumstances that the federal court case on which the appellant relied was not binding. But under the circumstances of this case, we're interpreting a federal statute and not a state statute, then I would submit that Thayer should govern over Romero. If the court has no further questions, I will rely on my brief and request that the court affirm the summary judgment. Thank you.
Thank you, Ms. Klein. Mr. Gowdy, rebuttal?
Thank you. I want to start with the fact that this is an affirmative defense. So my opponent, my friend, carries the burden of proof. So it's exactly like your Roach case that you brought up, Judge Jay.
I go by Thayer too. I'm checking.
But it's no different. Because this is an affirmative defense, they're the plaintiff. So basically what we're hearing is if the plaintiff's general manager comes in and testifies to something, we all have to accept it, despite all this circumstantial evidence and other evidence that you go through. It's up to juries to decide credibility. And what I heard from my friend was, this is not out of the realm of possibilities. Think if you had a plaintiff standing here saying, oh, I'm entitled to summary judgment or directed verdict. By the way, there's no distinction anymore, so I don't understand the whole argument I heard about the distinction between summary judgment and directed verdict. Think about if you had a plaintiff up here saying, oh, it's not out of the realm of possibilities. I was entitled to directed verdict. That's what we just heard. They're the plaintiff. That's what they're arguing. Nothing in the record says this. They're the plaintiff. They carry the burden of proof here. It's an affirmative defense. The other thing, all three of you are trial judges. I think you've seen people fib or color the truth. Mr. Matthews is doing so here, and we intend to prove it at trial. And a jury, not these three judges or the trial judge, determines that. That's the right to trial by jury. There's plenty of evidence that this was contrived after the fact. The question about actual service, it's relevant for the jury. It's not dispositive at summary judgment. And the vehicle was never serviced. It's not that it got serviced the next day. It was never, ever serviced. Which calls into question, how was this really something you were doing, or you made this up afterwards? As far as the date on the loaner agreement, we don't know what time of day. All we know, Judge Soud, is that it's dated 12/21/2016, which is the date of the accident, but there's no testimony about whether that was post-dated, like a lot of people do. We just don't know. And I would agree that would be speculation. Then I heard some argument that Thayer is binding. Just go read Brian Gardner's treatise on judicial precedent. This is black letter law. There's only one federal court in this country that binds this and any other court of a state, and that is the United States Supreme Court, period. This court is bound by its precedent, the precedent of the Florida Supreme Court, and the precedent of the Supreme Court of the United States, period. It is not bound by any federal court. We cited the Carlisle Carnival case. I could come up with 5 other cases if you want me to flood you with supplemental authority for that proposition. In any event, as I explained to Judge Boatwright, you don't have to say Thayer was wrongly decided. I don't think it was. I think it's a very distinguishable case. I gave you my hypo about the friend. This is pretty close to that hypo. This is the general manager of the defendant. He could have probably gotten the oil change for free. I think that's not quite a leap. And if it was something that was just going to be done for free, that's not consideration. That's not a rental agreement. And the facts construed in the light most favorable are either that the oil change was contrived or it was just going to be a favor to Mr. Matthews as the boss of everybody there. Of every single person of that dealership, he testified, he's their boss. So, and there, we had a honeymoon couple who were genuine customers who brought their vehicle in and paid for the service. Here, we don't have any record of even it being checked in to the service department. I heard about, the testimony was from somebody who wasn't the service manager at the time the vehicle was serviced. Well, this is their burden of proof. This is the witness they brought forward. They can't find the person who was the service manager at the time. Why is that our problem? It's not. It's her problem that they have that person testifying who doesn't know. Unless the court has any more questions, I'll rest. And would ask that you reverse the summary judgment and remand for a trial.
Thank you, Mr. Gowdy. Thank you both. It was well presented on both sides. If there's nothing else for the court, we will be in recess.